Welcome. Hold on. Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. We have celebrated 3 years of the Republican Professor podcast, over 218 episodes published. That's roughly 70 some per year. That's over one per week, 52 weeks in the year. We're cranking through and we're hitting now, just now, the Fourth Amendment. Can you believe that? The Fourth a frickin' Amendment. And I think it's worth reading the Fourth Amendment. No person shall be, oops, sorry, that's the Fifth Amendment. The right of the people, same phrase occurs in the Second Amendment, by the way. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation. Oath to who? And particularly describing the place to be searched and the persons or things to be seized. I'm going to read that again. The right of the people. Now, when you see that in the Second Amendment, there's a whole bunch of Democrats out there that go, that must be the right of the state. The state and the people are the same thing. Well, in that case, this would be a right of the government to be secure against unreasonable searches and seizures that are done by the government. Reductio ad absurdum there. The right of the people does refer to an individual right. Yes, that's right. So the dissent in Heller versus DC, DC versus Heller, actually, 2008, the dissent was wrong. It is the right of the people to be uh, to keep and bear arms. This is the right of the people too. The right of the people to be secure in their persons. See there you go. In their persons. That means it's not the government. The right of the people to be secure in their person, their house, papers, effects against unreasonable searches and seizures carried out by whom? Who's carrying out these unreasonable searches and seizures? Well, that would be not other people, that would be the government. People in their official capacity working for the government under color of law shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. I'm so glad that we can somewhat move on from the Second Amendment and do other things. I mean, thank God for Republican judges and justices on the Supreme Court and the U.S. senators and U.S. presidents that are in the Republican Party that have provided us somewhat of a break from some of the worst excesses we've seen in Second Amendment politics. The Fourth Amendment is almost always involving a law enforcement agency of some kind. 90% of police work is search and seizure. And I've wanted to do a Fourth Amendment case the entire time. I have mentioned a Fourth Amendment issues on the podcast, but never before have we done an entire episode just on the Fourth Amendment and applying it to a real case. The case I've chosen is one that I read mm, 11 months ago, I guess it was, 10 months ago. Paul Snitko versus the United States of America, specifically the FBI. Okay, so this is a federal case, and I'm in the United States Court of Appeals Ninth Circuit. This decision from a three-judge panel who had Carlos B. Mylan Smith and Lawrence Van Dyke. I believe this was in Pasadena. Yeah. This three-judge panel of the Ninth Circuit reviewed a case involving the FBI search and seizure of private lockboxes at a place called U.S. Private Vaults. I think it's important to read through this. So that's what I'm going to do. And I'm going to make comments about it. And I'm going to always keep the Fourth Amendment text, history, and tradition in view as we go through this. You're not going to become a, what the kids used to say, total expert, but you're going to move forward in understanding yet another aspect of not only contemporary politics, but how it applies to our public law, our constitutional law. All right, so we have the judiciary angle here, but this involves the executive branch. And of course, anything in the executive branch involves the Senate because the Senate confirms executive branch leadership. So, you know, for example, right now, President-elect Trump has announced his selection to lead the FBI, his selection to lead the United States Department of Justice as Attorney General. And those are political issues right now. The date of this podcast recording is 18 December 2024. Let's get to the opinion. Mylan Smith wrote the opinion. With whom B and Van Dyke join as to part one of the analyses, and with whom B, Circuit Judge, joins as to part two. Van Dyke writes a concurrence. Mylan Smith writes a concurrence to his own opinion. Ready? This case arises out of the government's inventory, quote, inventory. That's an interesting word to use. Why would they say inventory? Of 700 safe deposit boxes at U.S. private vaults, USPV, a company the government was investigating for various criminal activities, including money laundering. The government obtained a warrant to search and seize USPV's facilities and instrumentalities of its crime, including its, quote, nests of safe deposit boxes. The warrant issued by the magistrate judge explicitly, quote, did not, let me repeat that, did not authorize a criminal search or seizure of box contents, unquote. That's quoting the warrant. Is a warrant important? Let me see if the warrant's important in the Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue. Oh, so the warrants are important. But upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. In other words, the warrant has to be particular, and the judge decides what that particularity is and what is excluded from that particularity. You following this? It's not really rocket science. If you think that you must be missing something because I'm not a lawyer, stop with the I'm not a lawyer crap. Okay? Do you have common sense? Can you read? Boom. Good. You're on my side. We're on the same side, I should say. So the warrant issued by the magistrate judge explicitly, quote, did not authorize. Now, did is, it's one of those fancy things. It originally said does not authorize, but, you can bracket to make it grammatically correct. Does not authorize a criminal search or seizure of box contents, unquote. And that warrant required agents to follow their, quote, written policies, unquote, to inventory items and contact box owners so they could claim their property after the search. That word inventory is an important word because it brings into this whole interesting mix administrative law. And the link between administrative law and constitutional law is where we're headed. Okay. After the search at USPV, non-criminal plaintiffs Paul and Jennifer Snitko, Joseph Ruiz, Tyler Gauthier, and Jenny Verdon Pearsons, Michael Stork, and Travis May, these are the plaintiffs, made claims to the FBI seeking return of their property. The government refused to return their property, informing plaintiffs that it sought to civilly forfeit their property instead. Plaintiffs filed suit, and during the course of litigation, the government eventually returned all of plaintiffs' property. However, plaintiffs continued to press for equitable relief in the form of destruction of records, a remedy approved in United States versus Comprehensive Drug Testing, Inc. And that would be in the 621st volume of the Federal Reporter, the third series, starting at page 1162, specifically on 1172, for those who know where to find that in the law library, and that would be the Ninth Circuit, 2010. You can also find that on Google Scholar if you want. Just go to Google Scholar, go to cases, go to federal, type in U.S. versus comprehensive drug testing. Scroll down until you see 1172 on the side, and you'll see. Okay. After a trial on the briefs, the district court granted judgment in favor of the government, holding that plaintiffs' Fourth Amendment rights were not violated because the government's, quote, inventory, unquote, was not pretextual pursuant to our case law regarding the inventory search exception to the warrant requirement. Plaintiffs timely appealed. We have jurisdiction. Okay. And we reverse. Praise God. Now, am I rich enough to have one of these fancy schmancy safe deposit boxes? No. But I can appreciate why someone would want to have one. And I'm glad they exist. I don't think that everyone should know everything that you have at your home, or I don't think you should be forced to store everything at your home. There's a lot of reasons why someone would might have a rent a lockbox like that for valuables. Maybe they can't secure their home, or maybe their home is in a wildfire area, which is very common out here. One of my campuses that I taught at for over a decade, freaking half the campus was on fire, Pepperdine University. There are homes on Pepperdine University, which I always wondered, like, can those homes keep and bear arms if they're on a college campus? Isn't there some kind of rule against that? Anyway, that would be an interesting case to talk about. Okay, facts and procedural background. I'm on page 1253. By the way, you can find this in case you want to find it. Google Scholar. Google Scholar has the exact federal reporter. So when you go into the law library, you see those fancy books, that are really expensive, and you can't afford to have them in your home, probably. Actually, probably most lawyers couldn't afford to have them in their home or their law office. They and law libraries typically don't even have the newest ones. Last time I was in Chapman Law Library and Pepperdine Law Library, they were missing very recent years. I mean, I'm not talking about months, I'm talking about years. They were missing the recent years of those volumes. I'm not sure why. I'm not sure if it's an expense or what, but I think they only went up to 2018 last time I checked. Maybe they've gotten more recently. But I like the volumes. I like to go look at them, and there's numbers, and so this would be in the 90th volume of the fourth series. So that, if you're wondering what 90 means, yeah, yeah, there's 90 of these suckers. Um, and um, they have federal appeals court decisions from all the appeals courts. So this would be the 90th volume of the fourth edition of this fourth series, Federal Reporter, starting at 1250, and that's from 2024. So this year came down January 23rd, 2024. Now you don't need the volume. You can go to Google Scholar, hit cases, then hit federal, type in Snitko versus US. It'll probably pop right up. Look for 90F dot fourth 1250 2024. And I'm at starts on page 1252. Okay. So, and in when I print this out, the page number in the volume is on here. So Google Scholar tracks the page number of what will be in the volume. It's important to know that this stuff is published in books, and it's not it's not something that somebody could edit, you know, and change later. That's the importance of books. Books, you know, the kind that go in the library and they're on a shelf. You can mark it out with a pencil or pen, but that's not the same as editing it like at 2 a.m. for the whole world. Um, you could deface a particular volume, but you can't edit it. That's the importance of paper. And don't trust anybody that says we want to go paperless. That's a bunch of bull crap. You can't go paperless. You have to have it on paper. Okay. When the president signs legislation, it's paper. It's got to have his ink signature on it. Okay, we do not want digital stamps of the president's signature on law. That's not a good idea. It's not a good idea to have law that's editable by some intern at 3 a.m. after 5 beers. Okay. All right, USPV operated a business in Beverly Hills, California, which rented safe deposit box to its customers. Unlike banks, which also rent safe deposit boxes, USPV did not require customers to provide personal information, social security numbers, driver's licenses, or any other form of identification in order to rent a box. Sounds pretty good to me. That sounds great. Customers kept all keys to the boxes. Sounds wonderful. Are you kidding me? Yeah. USPV's facility featured significant security measures, including not iris scan vault access, so your eyeballs, 24/7 electronic monitoring, 24/7 armed response, and a time lock on the vault itself, which would work against any intruder except an intruder that is the government, right? Yeah, the government. You gotta that won't protect your stuff from being stolen by the government. What are you talking about? The government doesn't steal. Yeah, well, you wait. You wait. Protection of customers' anonymity was USPV's main selling point. On its website, the company explained, quote, "Our business is one of the very few where we don't even want to know your name. For your privacy and the security of your assets in our vault, the less we know, the better," unquote. The website even went so far as to say that it, quote, "would only cooperate with the government under court order," unquote. Perhaps unsurprisingly, investigations by various government agencies of individual criminals resulted in the execution of search warrants at USPV. For example, past searches pursuant to a warrant of individual safe deposit boxes at USPV have uncovered proceeds of crimes such as drug trafficking, illegal gambling, and prostitution rings. Government investigation into USPV. After years of investigating individual USPV box holders, agencies like the FBI, DEA, USPIS, that's the U.S. Postal Inspection Service, concluded that the individual investigations, quote, weren't doing anything effective, unquote, because the, quote, real problem, unquote, was USPV, which they believed served as a, quote, money laundering facilitator, unquote. It's amazing how interested and curious the government is when it comes to money. It's very interesting. I mean, not its own money, but your money or other people's money. Um, we can't get the Defense Department to pass out an audit, but we're really, we want to know what you have in there. Accordingly, the agencies opened an investigation into USPV's business and its principals in April of 2019. The investigation confirmed that the owners of USPV knew of its use by criminals to launder money, solicited illicit business, and committed several crimes themselves, not limited to money laundering. The agencies thus began discussions about obtaining indictments and warrants against the company. Internally, the agencies discussed taking USPV's business out, which they believed involved seizing, quote, eye scanners, the money counter, unquote, and, quote, nests of safe deposit boxes, unquote. It sounds like a movie. In the summer of 2020, discussions among and within the agencies began regarding the civil forfeiture of assets they expected to find within the safe deposit boxes. Special Agent in Charge Matt Moon contacted Agent Jesse Murray about the USPV investigation and quote, asked whether the FBI LA field office had the capacity to handle civil forfeiture regarding USPV, unquote. Murray responded that the office could handle a large-scale seizure, but she could not offer an opinion on whether there was probable cause to forfeit the assets until she reviewed the finalized warrant affidavit. Upon reviewing the affidavit in February 2021, prior to its submission to the magistrate judge, Murray determined that there was probable cause to seize the contents of safe deposit boxes. Remember, Murray here is just an agent. She's not, well, I'm assuming it's a she, but I guess Jesse. Oh, yeah, it says she. Murray is just an agent. Okay. She's not a judge. She doesn't approve the warrant. Okay. So her opinion is interesting, but it's not her opinion is not what the warrant says. So this is saying that the law enforcement agencies in question intended they intended to seize all of these boxes, the contents of them, the contents. They didn't just want the boxes. They wanted the contents of the boxes. Well, that means you got to open them up and you got to look inside. And that's called a search. In case you're not paying, in case you just now are joining us, that's called a search. Indictment and warrant application. On March 9th, 2021, a grand jury returned an indictment against USPV. The indictment charged USPV with conspiracy to launder, distribute controlled substances, and structure financial transactions. Structure financial transactions has to do with tax evasion. It's called structuring, meaning that's a technical term for evading reporting requirements, which would be, mm, I guess that would be a crime to evade reporting crimes. But see, here's the thing: is there's reporting requirements that kick in if you deposit a certain amount of cash. Okay. Um, I I don't know what the threshold is. It used to be 10,000. I'm not sure if it still is. Um, it wouldn't surprise me if it still was. I don't know. I don't typically have that kind of cash on me to deposit myself, but um, I think it's per day, 10,000 per account per day. Um, Beyond that, there's a report that's issued to the IRS. Um, and that's called a reporting requirement for the bank. Structuring has to do with actions, conduct that you undertake to avoid that reporting requirement. The the thing is that ordinary non-criminal events would could possibly look like structuring, meaning avoiding reporting requirement. Meaning it could be that you sold a car for $9,000 and you're putting the cash in, and then you sell a computer and you sell your CD collection and you sell your, you know, your cubic zirconium ring, which you thought was a diamond, and the other person thought it was a diamond. And again, you have $9,000. And then it, it looks like you're avoiding depositing 18,000, but but it's lawful what you were doing, and you're not really avoiding anything. You were just depositing the money when you got it. Um, does that make sense? I have family members that are involved with this structuring, how to find structuring. I have family members that are pretty high up doing that. By high up, I mean at the highest levels, creating and selling software that helps find that. And there is invasive software that does spy on you and reports things. In other words, there's software that's designed to discover uh, what they would say would be likely evasion of reporting requirements. Um, so that's probably what's being used here. The indictment also included forfeiture allegations, which reflected a finding of, quote, probable cause to believe, unquote, that certain items to be seized were, quote, subject to forfeiture, unquote, such as, I'm just going to stop saying quoted unquote, okay? I'm just going to read it because it's a little bit tedious. Such as the nests of safety deposit boxes and keys. The two forfeiture counts stated that the United States will seek forfeiture of USPV's property in the event of defendant USPV's conviction under the counts of the indictment. Okay, that was important. The forfeiture counts said that the U.S. would seek forfeiture of the owner's property, the business's property, not the stuff that's been rented out, because that's not their property. The business property in the event of a conviction. That means there's got to be a plea deal or something. About a week and a half later, on March 17th, 2021, the government submitted applications to Magistrate Judge Steve Kim for search and seizure warrants, both of which included a common affidavit by Special Agent Lynn Zellhart, the agent in charge of the FBI's investigation. The affidavit, see, there's your oath or affirmation. See, remember, so this follows the Constitution, this process. The right of the people to be secure in their persons, houses, papers, and effects. What am I doing? I'm reading the Constitution and the Federalist Papers edited by Charles Kessler, who was my professor when I studied the Federalist Papers in a class called The Federalist for my Ph.D. in public law. The right of the people to be secure in their houses, um, in their papers, houses, paper effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation. So the agent has to swear that there's probable cause here, but it has to be proved by a judge. This is to meet the reasonability requirement in the Fourth Amendment. It's got to be a reasonable search. So this is what reasonable means here. The affidavit largely discussed how USPV's business operated, including how its owners knew its boxes were rented to facilitate money laundering. According to an exchange between a confidential informant and the owner of USPV, the owner stated, "Listen, you don't want every drug dealer in your place either. You need normal people too." Wow, that's interesting. The affidavit explained that this statement suggests that drug dealers comprise the majority of USPV customers, and the business has to make an effort to attract non-criminal clientele as well, so as not to be too obvious a haven for criminals. That was a quote. The affidavit also noted that the government sought to seize the box nests as, quote, evidence and instrumentalities of USPV's criminality. It explained that the, quote, search and seizure warrants the government seeks authorize the seizure of the nests of safe deposit boxes themselves, not their contents, unquote. But immediately after that sentence, the affidavit read that, quote, by seizing the nests of safety deposit boxes, the government will necessarily end up with custody of what is inside those boxes initially, unquote. Quote, I'm doing quotes now because this language is important. To protect their agencies from claims. Pay attention here, guys. This is where the administrative law comes in. See, now you got procedures for how to handle these boxes, right? You got regulations. To protect their agencies from claims of theft or damage to the contents of the boxes, unquote. The affidavit stated that, quote, agents will follow their written inventory policies, unquote. The affidavit also stated that, and this is a longer block quote, agents will attempt to notify the lawful owners of the property stored in the boxes how to claim their property, such as by posting that information on the internet or at USPV itself, or by contacting the owners directly. In order to notify the owners directly, agents will, in accordance with their policies regarding an unknown person's property, look for contact information or something which identifies the owner. Okay, you have to understand the manipulation of administrative law. The temptation is so great here because who stands to gain? Well, it's the government that stands to gain by seizing whatever is in there. And it's your word against theirs about what was in the box. So what they're doing is they're trying to have a reason to open the box. And the warrant says you can't open it to search it. So the government is looking for a way to open the box, but not call it a search because the Constitution prohibits searches and seizures that don't follow the constitutional guidelines. What they're looking for is an exception to the warrant requirement to open the box. And the exception will be guided by their regulations. That's administrative law. in order to protect the government from their fear, so they say, of being held liable for theft. Now, this is really ironic because what the government has in mind, of course, is theft. That's exactly what they want to do. They want to steal whatever's in these boxes that doesn't belong to them. And the process is civil forfeiture. They say that all they say it now belongs to us. Well, that's exactly what a criminal says. If a criminal is walking by you in the dead of night and takes your purse and says this belongs to me, that's called stealing. When the government does that, they call it civil forfeiture, but it's the same thing. So, but because of the administrative law doublespeak here, which has a place in the legal analysis here, and so you have to parse it because you have to admit that there is possibly a place for regulations of that kind. But this is the beauty of these judges is they're parsing the difference between constitutional and administrative law, and they're calling the FBI out on the bullcrap. This is why I chose this case. Okay. So, to protect their agencies from claims of theft or damage, they will follow their written inventory policies. Agents will attempt to notify the, um, so they will look for contact information or something which identifies the owner. And they're claiming, if I have the box, I don't know who the owner is. I can't contact anybody about coming and getting their box. They may be innocent of these charges and they're just an innocent person and they have their stuff in there. But in order to find out who it is, we have to open the box. That's what. So they're looking for any reason to get inside that box. Okay. The USPV recommends that the box renters include their designees' telephone numbers on a note in the box in the event that USPV removes the contents for non-payment of rental fees. Okay. A footnote in the affidavit explained that the FBI policy regarding taking custody of an unknown person's property provides, in part, that agents inspect the property as necessary to identify the owner and preserve the property for safekeeping. You see how Orwellian this is? They don't want to preserve it for safekeeping, they want to take it. But it's under the guise of this is a service we provide. And the inspection should extend no further than necessary to determine ownership. Sure. Yeah. So they open it up, and let's say there's cash, jewelry, maybe documentation, and there's a note on the very top that says, let's say everything else is occluded from view. And there's a note, like a post-it note saying, I am so and so. And let's say it's even in a manila envelope. The FBI is saying, we're not going to look in that manila envelope. We're just going to look at the post-it note and just do as much as we have to find ownership. Well, that's not what they're. Who is there to check whether the agent is looking in that manila envelope? Of course they're going to look. Of course they're going to look. That's why they're opening the box. Now, I mean, apparently these boxes have numbers on them because the how else would the owner know which box to go to with their key, right? The renter. So it could be the FBI could store these and then just issue a public notice that, if you have the keys to such a box, you can come get your box. And if you're not one of the people that we're investigating for criminal activity, then you can take that box. You're not under our jurisdiction. Mm-mm. No, They wanted all the boxes, and they wanted to have a reason to get inside the boxes and and keep it. That was their original plan for everything, including innocent people, and under the guise of an inventory. Why? Because there's nothing in the Fourth Amendment that prohibits an inventory for administrative purposes to safekeep, you know. And so we're covering this because you need to know what the tricks are. You need to know what some of these issues are. Ultimately, the warrant issued by Judge Kim approved the following items to be seized at USPV: the business computers, the money counters, the digital and video surveillance and security equipment, the biometric scanners, and, quote, the nests of safety deposit boxes and keys. Well, what do you mean by nests? Don't you just mean all of them? Or do you mean the nest just of the criminals, in which case that would be a subsection, not the innocent people? With respect to this last item, the warrant stated, this warrant does not authorize a criminal search or seizure of the contents of the safety deposit boxes. In seizing the nests of safety deposit boxes, agents shall follow their written inventory policies to protect their agencies and the contents of those boxes. Also, in accordance with their written policies, agents shall inspect the contents of the boxes in an effort to identify their owners in order to notify them so they can claim their property. In other words, this warrant said, in an effort to notify the owner of the box, which the owner's going to come forward, right? They're going to come forward. They don't have to open the box. But, okay, you can peek inside to just find who the owner is. But that's it. You can't do more than that. You can't count cash. You can't look at really closely at the diamonds. You can't read the bearer bonds. You know, you can't, if there's bank documents in there from Zurich, you can't read those. You have to restrict it to the surface level identification. Although the warrant provided that agents must, quote, follow their written inventory policies, unquote, the details of those written policies were not included in the government's application for a warrant, except for the one sentence above regarding the unknown persons policy, the written inventory policy. The FBI's inventory policy is contained in its Domestic Investigation and Operations Guide, which Zellhart described as a dictionary or thesaurus for FBI agents. The DIOG instructs the agents that after lawfully taking custody of the property, they must conduct a prompt and thorough search of the contents of the property, including searching any locked or unlocked containers and inventorying their contents. Agents must then record the results of the inventory on certain specified forms, and the summary must include, but is not limited to, a description of the property and the items secured for safekeeping. The DIOG provision further instructs that agents may not conduct inventories solely for investigative purposes, and that whenever there is probable cause to believe an inventory search would also yield items of evidence or contraband, agents must obtain a search warrant when feasible. So the policy regarding custody of an unknown person's property, the warrant also referred to an FBI policy on the procedure to follow should the agents come into possession of an unknown person's property. That policy states that agents should inspect the property as necessary to identify the owner and preserve the property for safekeeping, and that such an inspection should extend no further than necessary to determine ownership. The district court below found that the unknown person's property is separate from the FBI's inventory policy. However, the only written reference to language matching this unknown person's policy in the record is on the same page of the DIOG above, which discusses inventory searches. The language is contained in a provision titled Administrative Inventory Searches of Lost or Misplaced Items. As with the inventory policy, these instructions state that if within the scope of the examination necessary to determine ownership, agents discover incriminating evidence or contraband, agents should seek a warrant to continue the search absent emergency circumstances, unquote. Are you guys following this? All right, we're going to continue there next time. We stopped almost getting to the bottom of 1255. We'll continue in the preparation and execution of the warrant. And we'll be making comments along the way as far as how administrative law intersects with constitutional law and why an FBI supervision of the people is necessary. Because you're going to see that the FBI ignored the search warrant. They did whatever they wanted to do. And you have to be aware that that happens. You have to be aware as a voter that this is the tendency of people in power. We all have a sinful nature. And the founders believed that. The framers of the Constitution wrote the separation of powers in there to try to protect individual liberty. And of course, the Bill of Rights, of course, is there as a restriction on government. Why? Because government is run by people in power who want more power. And they tend to abuse the people. They tend to abuse their own people. That's the tendency of government. And so you have to be aware that that's what's happening. And that's what could happen. And it could happen in very sophisticated ways that would otherwise escape your notice. And it's very important to have the right judges in there and the right people running these agencies like the Department of Justice and the FBI. This is a very timely piece that we're doing here on The Republican Professor, as senators are discussing right now whether they're going to vote yes or no on Donald Trump's appointments to run the FBI. Another aspect of this is the educative aspect of this. And of course, this is The Republican Professor. So we have an educational purpose in this podcast. This is not for profit. And what I'm trying to get across to you is that the founding was good in many respects. The constitutional heritage, American constitutionalism, as a defining feature of our ethnicity, our national ethnicity, is good. It's a light to the nations. It's good to keep sin in check in appropriate ways, and this is appropriate. And if you lose that thirst and desire to protect the Constitution, if people going to college learn to hate America and hate American constitutionalism, we will suffer from it. Those people will suffer from it. In order to protect flourishing that has a necessary condition of individual liberty, we have to keep our eye on the ball on these things. So that's what we're doing. Thanks for joining me on The Republican Professor. Now more than ever, it's important to support the work of the Republican Professor. Please send us a donation. We're at Venmo at The Republican Professor. You can also buy me a cup of coffee or 10 at Buy Me a Coffee, Lucas J. Mather. I'll put the link in the description below. We'll see you next time.